Ibanga Silas Eden. Structures Limited. My lord, parties are absent.
Okay, parties absent.
Yes, my lord.
Okay. Parties absent. Yes, appearance, Mr.
Pitandem, Milo. Yes, my Pitandem. Yes, my lord. For the claimants. Apologize for the absence.
Is that not Mr. Peter? Okay,
Pitandem,
Peter.
yes. Pitandem. Yes, for the claim.
Okay, Peter and them.
Yes, sir. No, the very short time. Okay. Oh.
So this is my judgment. The claimant commenced this suit against the defendant by a general form of complaint and other accompanying processes dated and filed on 22nd of May 2024, praying the court for the following reliefs. Number one, a declaration that the claimant is entitled to the sum of 1.7 million naira, being his 7-month outstanding salaries for the month of June 2023 to December 2023 at 250,000 naira per month. Number two, a declaration that the claimant is entitled to the sum of 828,000, being his monthly severance benefits deducted as source from January 2018 to May 2023, which has not been paid to the claimant even after his resignation in December 2023. Number C, a declaration that the claimant is entitled to the sum of 221,000 naira, being claimant's yearly leave allowance for 5 years, 5 months, January 2028 to May 2023. Number D, or 4, a declaration that the claimant is entitled to the sum of 1,020,000 naira, being claimant's outstanding end of the year / Christmas bonus for 2028 to 2023 at 250,000 naira per year. Number E, a declaration that the claimant is entitled to the sum of 200,000 naira, as well as 300,000 naira, being claimant's outstanding long service award and operational expenses from March 2023 to December 2023, respectively. Number F, an order that the defendant pays immediately to the claimant the total sum of 4,799,000, being the total sum owed the claimant by the defendant as shown in paragraphs A, B, C, D, and E above. Number G, an order that the defendant pays to the claimant the sum of 100,000 naira as general damages for unlawfully 100 million naira as general damages for lawfully withholding claimants' entitlements and subjecting them to untold hardship and spurious ridicule after serving the defendant meritoriously for over 13 untainted years. Number 8, an order of court awarding 10% prejudgment monthly interest on the sum of 4,799,000 naira. Then the total sum all the claimed by the defendant as shown in paragraphs A, B, C, D, and E above, and 20% post-judgment interest on the entire judgment sum until judgment sum is fully liquidated. Number I, the cost of this action in the sum of 2 million naira against the defendant. Number J, and for such further order or orders, this honorable court may deem fit to make in the circumstance. Upon service of the notion processes, the defendant by leave of court filed his memorandum of appearance and settlement of defense on the 1st of July 2024. At the trial, claimant testified as CW1 on the 6th of February 2025 and adopted his witness statement on oath dated 22nd of May 2024. He tendered exhibits ISI 1 to ISI 8A and B, which are admitted in evidence and marked as such. CW1 also acknowledged the receipt of the sum of 2,999,902 naira from the defendant as the amount admitted in the defendant's statement of defense. The claimant was then cross-examined and discharged. On 28th of October 2025, the defendant Human Resources Manager testified as DW1. He adopted his statement on oath dated 31st of July 2024 and was cross-examined. As there was no re-examination, DW1 was discharged and the matter was adjourned to the 17th of February 2025 for adoption of final written addresses. On 17th of February 2026, the defendant counsel asked for an adjournment to submit a final written address, leading the court to adjourn the matter to the 20th of April 2026 at the defendant's instance. On that date, the case was further adjourned again to 11th of May 2026 as the address remained unfiled. And when the case was called on the 11th of May 2026, the defendant still had not filed the address despite having been served with a hearing notice. Consequently, the court adjourned the matter to the 10th of June 2026 for the adoption of final written addresses. When the defendant failed to file her final written addresses, the claimant filed his final written address on the 11th of May 2026, wherein his counsel formulated 4 issues for determination, to which: number 1, whether the claimant is entitled to the sum of 1,020,000 naira being outstanding end of the year / Christmas bonus for 2028-2023 at 250,000 naira per year. Number 2, whether the claimant is entitled to the sum of 200,000 naira as well as 300,000 naira being outstanding long service award and operational expenses from March 2023 to December 2023 respectively. Number 3, whether the claimant is entitled to the general damages of 100 million naira. Number 4, whether the claimant is entitled to the sum of 2 million naira being cost of litigation. Counsel submit that the end of the year / Christmas bonus is an entitlement of the claimant and not ex gratia. Counsel referred to Article 44 of NJIC Agreement, Exhibit 5. Counsel also submits that in the instance case, there's no evidence that the defendant incurred losses, nor that there was any dialogue. The defendant witness under cross-examination admitted that the employment of the claimant is regulated by Exhibit 5 and is entitled to all the benefit both in the letter of employment and the NJIC agreement. Counsel continues that in the process of evaluation or assessment of evidence, The court will be guided by recognized considerations such as admissibility of evidence, relevancy, credibility, probability, and conclusiveness of the evidence. Counsel rely on the cases of Mogaji and Odofin, White and Jack, Adeleke and Itanda, and submitted that the evidence of the claimant in proof of his two claims of end of their Christmas bonus and site expenses is admissible, relevant, credible, probable, and conclusive. Counsel further contends that the course of action is at the discretion of the court. Counsel rely on the case of Okwejimoni and Mbakeji and submit the cause follows event that defendant deprived the claimant of his wages and other entitlements, that she waited until the claimant instituted this action before she suddenly realized his obligation to pay the claimant wages and other entitlements. Counsel finally urged the court to grant the claimant's reliefs. So this is my opinion. After a careful examination of the pleadings and the evidence of the parties, as well as a submission of the landed counsel for the claimant, I've chosen to identify a loan issue for determination to it. Whether having regards to the nature of and circumstances of this case, the claimant is entitled to the reliefs sought. From the pleadings filed, the claimant advised that he was employed by the defendant on the 4th of October 2010 and resigned from his dual roles as safety officer and chief security officer on 14th of April 2023, citing extremely degrading and dehumanizing treatment. Claimant also advised that his last salary payment was for May 2023, leaving 7 months worth of wages, June through December 2023, unpaid at 250,000 naira per month, totaling 1,750,000 naira. Additionally, he claims outstanding entitlements, including 5 years worth of leave allowance, end of year / Christmas bonuses, a 200,000 naira long service award, and unreimbursed site operational expenses. The claimant maintains that the defendant total indebtedness stands at 4,799,000 naira. Frustrated by the situation, he engaged a solicitor to issue demand letters, and the defendant responded with a letter dated 7th of March 2024, pledging to settle by the end of April 2024, but has since flagrantly failed to honor that promise. At the proceedings of 30th October 2024, claimant's counsel made an oral application for judgment as per paragraph 10 of the defendant's statement of defense, admitting the sum of 2,299,000 naira, and asked for another date to prove the remaining sums. The court then, in its brief ruling, entered judgment in favor of the claimant as per paragraph 10 of the defendant's statement of defense, and accordingly ordered the defendant to pay the claimant the sum of 2,999,902 naira. For the remaining claims, it is settled principle of law that the burden of proof in civil cases rests on the party who asserts to prove his case with credible and admissible evidence. This position of the law is encapsulated in Section 131 of the Evidence Act 2011. Similarly, the Supreme Court in the case of Tumidu and INEC, per Adamu Joro, held thus, and I quote, "He who asserts must prove, and the burden of proof lies on the party who will fail if no evidence at all is given on another side," unquote. In proving his claim, the claimant tendered 8 exhibits. Exhibit 1 is the claimant's employment letter. Exhibit 2 is his appointment letter as chief security officer. Exhibit 3 is his letter of upward review of his salary, of his monthly emolument. Exhibit 4 is the claimant resignation letter. Exhibit 5 is NJIC agreement, while exhibits 6 and 7 are solicitors' letters. Based on the claimant's testimony, it is uncontested that the defendant employed him as reflected in Exhibit 1. The employment letter is equal that the employment relationship is subject to Exhibit 5, which sets out the National Joint Council terms and conditions of service for all junior employees in Nigerian building and civil engineering industry. The court also has before it Exhibit 5 days resignation from that employment. However, what appears the claimant was not paid his end of the year / Christmas 2023 and side operational expense on the claim of 1,020,000 being outstanding end of the year / Christmas bonus for 2028. The defendant in effort depending on the fortunes of the company for each year and cannot be claimed as of right. However, Article 44 at page 17 of the NJIC Agreement, Exhibit 5, provides as follows, and I quote, all employees will be considered for end of year bonus. The amount shall be 1 month based on court. It's well established in law that the terms of an employment contract are binding on all parties thereto, and neither side, including the defendant as the employer, is permitted to depart from the provisions set out in Exhibit 1 and 5. See the case of Federal Polytechnic Ida and Agbeke by Agim, JCA then. For the side operational expenses, the claimant asserts that upon his promotion to a dual role on 6th of October 2021, his monthly side operational expenses were increased from 15,000 naira to 30,000 naira, but he was not paid for the period from March 2023 to December 2023, resulting in outstanding arrears of 300,000 naira only. It can be observed that Exhibit 2 appears to corroborate the claimant's assertion. The exhibit says thus, and I quote, in view of the foregoing development, your monthly salary has been increased from the existing 130,000 naira only to 250,000 naira only, while your monthly operational expenses has also been upgraded from 15,000 naira to 30,000 naira. Counsel for the defendant has contended that operational expenses are payable on a subject basis, contingent upon the prevailing requirement of the activities undertaken, and that the defendant bears no obligation to pay where no such activities were carried out. However, no agreement to that effect has been tendered in evidence before this court. There is thus no factual foundation upon which this court could reach the conclusion that the side operational expenses are so conditioned, as the court of law is precluded from supplementing the evidence placed before it or from deciding a case on mere conjecture. I hold that this court cannot read any extraneous terms or conditions into the document already in evidence. See the case of Ogbonna and AG, Imo State, Excel Plastic Industry, and First Bank of Nigeria. It must be stressed that the relevant provisions in Exhibit 2 and 5 definitely show that the claimant's monthly side operational expenses rose from 15,000 naira to 30,000 naira, and he's entitled to the end of year bonus, consistent with the well-established rule of construction. When a statutory provision or contractual term is clear and free from any doubt, the court must give effect to its plain and ordinary meaning. In the light of the above, therefore, claimant is entitled to the sum of 1,020,000 naira as end of year bonus and 300,000 naira being his side operational services from the month of March 2023 to December 2023. The claimant contends that having served the defendant meritoriously for over 13 years, is also entitled to voluntary resignation to long service award of 200,000 naira as enshrined in the National Joint Industrial Council agreement on terms and conditions of service for all junior employees in the building and civil engineering industry in Nigeria. I've thoroughly examined the NJIC agreement. It's clear to me that Article 22 at page 11 has made provision for long service award. The relevant provision is hereby reproduced for proper appreciation as follows. 10 years, 21 color TV plus 1 month salary. 15 years, 26 color TV plus 1 month's salary. 20 years, 2-door refrigerator plus 2 months basic salary. 25 years, 100,000 naira cash payment in lump sum. 50 years, 150 cash payment in lump sum. Unquote. The clear and unambiguous terms of the NJIC agreement, which are binding on both parties, definitely set out the defendant's obligation regarding the administration of the long service award. The pivotal question, therefore, is whether the claimant qualifies for this benefit. As previously noted, his employment tenure ran from 4th October 2010 until his resignation on the 14th of April 2023, a period exceeding 13 years. Going by the above, the claimant is entitled to the sum of 200,000 naira being the payment for long service award, having served the defendant for over 13 years. On the issue of general damages in the sum of 100 million naira only for lawfully withholding the claimant's entitlement, it is the law that general damages are always made as a claim at large. The quantum need not be pleaded and proved. The award is quantified by what, in the opinion of a reasonable man, is considered adequate loss or inconvenience which flows naturally, as generally presumed by law, from the act of the defendant. See the case of Alhaji Ahmadu Gari and Serafina Nigerian Limited. As evidenced by the defendant's solicitous letter exhibits 8A and B, the defendant contends that the salary payment delay was not deliberate, but rather arose from operational constraints stemming from the country's prevailing economic conditions. The defendant further undertook to settle the debt and has since made partial payment towards the claim. In light of these circumstances, I find that an award of damages is not merited. Accordingly, the claim for general damages is declined. For the claim of prejudgment interest at the rate of 10%, the law is tried that before a party can claim prejudgment interest, he has to plead not only his entitlement, but the basis upon which entitlement, but the basis of his entitlement, either by statute or contract/agreement between the parties, or under mercantile custom, or under the principle of equity. See the case of Antama and Unity Bank. It is for the claimant to prove his entitlement to the stated prejudgment interest. SARS must prove same. This the claimant has failed to do. Not having proved same, the claim of prejudgment interest is refused and is hereby dismissed. For the post-judgment interest, so at the rate of 20% on the judgment sum from the date of judgment till final liquidation. Order 47 Rule 7 of the NICN rules states thus, and I quote, the court may at the time of delivering judgment or making the order give direction as to the period within which judgment payment is made or other act is to be performed, and may order interest at the rate not less than 10% per annum to be paid upon any judgment, unquote. Therefore, pursuant to Order 47 Rule 7 above, the claimant is entitled to 20% per judgment interest per annum until final liquidation. On the whole, and for the avoidance of doubt, the claimant succeeds to the extent that the following reliefs are granted. Number one, the defendant is ordered to pay the claimant the sum of 1,020,000 naira being the outstanding end of year / Christmas bonus for 2018 to 2023 at 250,000 naira per year. Number two, the defendant is also ordered to pay the claimant the sum of 300,000 naira being outstanding side operational expenses from March 2023 to December 2023. Number three, 200,000 naira shall also be paid by the defendant to the claimant as outstanding long service award. The above sums shall be paid to the claimant within 1 month of this judgment, failing which it shall attract 20% interest per annum until fully liquidated. Judgment is accordingly entered, which 500,000 naira cost to be paid by the claimant, by the defendant to the claimant. Mr. Peter. Mr. Peter.
Lord. Yes, my Lord. I'm grateful for the judgment, sir.
Thank you.
Thank you. Thank you.
Mr. Peter, the 200,000 naira long service award.
Yes, sir.
Wasn't it given to you?
No.
Okay, it wasn't given.
Yes, we contested.
No, they didn't contest it. The 200,000 naira.
Hello?
I said the 200,000 naira long service. Okay. It's there in judgment.
Yes, sir.
Thank you, Mr. Peter. Thank you.
Thank you very much. Thank you.
Okay.
Number 4.
Mr. Okon.
Yes, my lord. Yes, my lord.
Oh, yes, which one? The mobile cases, are they ready?
Yes, my lord, they are ready.
Okay.
Yeah.
Yes.
Suit number NICN UY 28 2024 between Joseph Effiong Achibong and 21 others, and Mobile Producing Nigeria Unlimited. My lord, parties are absent in court.
Okay. Parties absent. Yes, appearance. Mr.
Respectfully, my lord.
The
Yes, my lord.
the Vorasi.
Respectfully, my lord. D. Vorasi.
Yes, for the claimants.
Yes, my lord, for all the claimants.
Yes.
May it please the court. Yes, my lord. May it please the court.
Thank you. Yes.
Thank you, my lord.
Yes. I can't see the counsel for the defendant.
My lord is there.
My lord, they are indicated here. I can see the
The
learned
learned
SN. I don't know
is
what
there.
happened. If Unaya now they too.
But I can't see him. I cannot see.
My lord, I don't know what happened. But their names are indicated on the
I can see me,
dashboard here, my lord. As a couple.
Can my lord see me now?
No, I can't see you.
Okay, let me see if it is.
No, you can still talk. We can.
Very well.
We don't need to see you once we can hear you.
Very well. Very well, my lord. My lord, the motion appears for the defendant, and I'm pairing with my learned friend, Funaya Nabode.
Okay. Let us say with
If Funaya
yes,
Nabode.
yes.
Na hyphen Ude.
Nanya, yes. So okay, thank you. For the defendant.
Yes, my lord.
Okay. There's only one defendant for the defendant. Yes, Leonard, Mr. Vurasi.
Yes, my lord. My lord, the matter is slated today for hearing.
Yes.
My lord, if the business of the court so permits, we are ready to adopt our process, my lord.
Okay.
Yes, my lord.
Lana Esen, you ready?
Call, please.
Okay. Yes, Mr. Vurasi.
Yes, my lord, before the Honorable Court is our originating summons.
Yes.
My lord, he said originating summons was filed, is dated the 12th day of July 2024.
Okay, just hold on.
As the court pleases.
Yes, Mr. Vurasi, yes. We have lost Mr. Vurasi. Yes, Mr. Burasi.
Yes, my lord.
Uh-huh.
My lord.
Yes, Mr. Burasi, I can hear you.
Yes, my lord. It's dated the 12th day of July 2024
Okay.
and filed on same date, my lord.
Our ordination summons.
Yes, my lord. Expired 12th day of July 2024 and dated same date.
Is filed, is dated and filed, is dated.
Yes, my lord. 12th day of
filed
July.
on 24th.
12th day of July 2024.
Okay, so
2024, my lord.
Okay, July
Yes,
2024.
Yes.
Yes.
My lord, the originating summons, in the said originating summons, the claimant claims two principal reliefs
Yes.
are set out
Okay.
in the originating summons.
Yes. What are the reliefs?
Determine the questions. My lord, one is to be entitled to be reinstated to 100% of their annual pensions from the present 75%, my lord, effective from the first day of February 2006 and first day of February 2014, my lord.
Yes.
2, payment of all arrears and all shortfalls of 25% of their pensions by the defendant from first day of February 2006 and first day of February 2014 to when they are fully reinstated to 100%, my lord.
Yes. Yes.
Yes. My lord, the questions are as follows. A,
Yes.
whether or not the claimants are entitled to be paid 100% of their pensions after retirement from the dependent company. B, whether or not the claimants are entitled to be paid 25% arrears of pension unduly withheld by the defendant after the expiration of the commutation period of 15 years. And C, whether or not the claimants are entitled to be reverted to 100% of their pensions. My lord, in support of the originating summons, is a 22 paragraphs affidavit in support. My lord, the said affidavit was deposed to by the first claimant on record. My lord, attached to it are exhibits A1, A to A2, B, C, and D. My lord, in compliance with the rules of court, is
Yes,
awaiting
Mr.
address.
Burasi.
Yes, my lord.
How many paragraphs?
My lord, 22 paragraphs.
Okay. Yes.
Yes, 22 paragraphs, my lord. Deposed to by the first claimant. Yes.
Okay.
And exhibit A, A1, A2.
Okay.
Yes. My lord, there's also exhibit B, C, and D attached to the said affidavit.
Deposed by the first claimant.
Yes, my lord. Yes, my lord.
So how many exhibits? How
My
many
lord, we have exhibits A.
Exhibit A, yes.
Exhibits A, A1 to,
Okay. A1.
to B.
A1 to B.
A1, A2. No, my lord. We have exhibits A, A1, and A2.
Yes.
Then there's also exhibit B, C, and D.
Okay, exhibit B and D.
Yes, C and D. Yes, my lord.
A1, A2, B.
Yes, my lord.
B, C, and D.
Yes, my lord.
B, C, and D. Yes, yes,
Yes, my lord.
yes.
My lord, in compliance with the rules of court, is a written address.
Okay.
My lord, in the said written address, we formulated 3 issues for determination.
Yes.
My lord, they are already there
Yes.
in the written address.
Yes.
My lord will adopt them, and we urge my lord to give judgment in favor of the claimants. May it please the court. My lord, upon receipt of the counter affidavit of the defendant,
Yes.
the claimants also filed a further affidavit. My lord, the affidavit is also deposed to by the first claimants on record. My lord, it's 12 paragraphs for the affidavit.
Okay.
Yes. And also a reply on points of law
Okay.
dated 8th day of June 2026, but filed on the 11th day of June 2026.
Dated when?
My lord, is 8th day of June.
Okay.
My lord, 8th June 2026.
Okay.
Yes, but filed on the 11th day of June 2026.
Okay.
Yes, my lord, we adopt them as our argument, and we urge my lord to give judgment in favor of the claimant. May it please the court.
Yes, Lana. Yes, Lana is.
Yes, thank you, my lord.
Thank you, Mr. Wilson.
Yes, my lord. My lord,
Yes.
we have filed a counter affidavit
Okay, we're opposed to the.
in opposition to the originating summons
Yes.
on the 24th of April 2026.
On the
24th of April 2026.
okay, 24 April 2026. Yes.
Yes, my lord. It's a counter affidavit of 11 paragraphs.
Okay.
We are relying on the paragraphs of the counter affidavit.
Okay.
Attached to the counter affidavit are exhibits
Yes.
marked exhibit MPN1, MPN2, MPN3.
Exhibit MP.
MPN as a mobile producing Nigeria. Yes,
Yes.
MPN1, MPN2, MPN3.
Okay. Yes.
We are relying on all the exhibits.
Yes.
In compliance with the rules of this court, we have filed a written address
Okay.
on the same date.
Yes.
We have formulated two issues for determination. My lord would notice that the two issues we formulated are different from the issues formulated by the claimant.
And in an action filed by originating summons, can the respondent or defendant formulate his own issues different from the ones submitted by the.
That is why I am raising the point, my lord, because ordinarily we should be bound by the issues. Formulated by the claimant.
Yes.
But our position is that
and you don't have a counterclaim.
No counterclaim. No counterclaim.
Yes.
But my lord, our position is that the issues formulated by the claimant do not flow from the facts and the documents before the court.
Present. Okay.
Yes. So the issues that we have formulated captures more the issues that flow from the exchange of pleadings and documents by the parties.
What are the issues that you have formulated?
The first issue is whether the second to 22nd claimants, whether they do not have the same interests as the first claimant in this suit. My lord will appreciate that in the claimant's formulation of issue, they will not raise that because they are the claimants. So this is an issue of law, and it is fundamental to the jurisdiction of this court. whether the first to 22nd claimants have the same interest, which would enable them to bring this suit together.
And this appears to be, an objection in disguise.
So to say.
That not?
So to say, yes, my lord may be right to say it's an option in disguise, but
Yeah.
Because it is fundamental and the claimant has had opportunity to respond to this in their reply points of law, so they are not taken by surprise. Yes.
And the second issue, is what?
So the second issue is it has two legs, two limbs. The first limb is whether the pension was governed by the Mobile Producing Nigeria Handbook, 1980 to 20,000, which is the claimant's Exhibit B.
Okay.
Yes, because that's the document, that's the foundation upon which they are bringing their claim. So the first limb of that issue is whether their pension or the what I'll call the arrangement that the parties entered into was governed by that handbook. If the answer is affirmative, if that handbook is the applicable contract or document to the pension that they claim, clauses 7.7.2 of the same handbook as the B, does it set the maximum pension amount that the claimant are entitled to? The reason for this issue is because it is our position that if clause 7.7.2 is read literally and the ordinary meaning is given to it, then the conclusion will be that what they are claiming doesn't sit within clause 7.7.2. And as a matter of fact, on the strength of the evidence that they have even produced, we are paid more.
Maybe at the time of the payment of the lump sum, even though the clause 7.7.2 says 25% of the total 5 years pension paid as lump sum, but in the case of the claimant, they are given 40 and I think there's 75%. So maybe they are given higher than what the clause is even talking about. And
go on, my lord.
Yeah, the clause is saying an employee may elect to receive part of his future pension in lump sum.
Yes,
the maximum amount to be received shall be 25% of the total of 5 years pension paid as lump sum, while the remaining 75% is paid monthly as pension over as pension over 60 months. After the 5th year, the pensioner shall revert to total monthly pension.
As the court pleases.
But in the case of the claimant, they are given how much percent? And in this case, they are given 60 or 75.
75, my lord.
The claimant is here. Let him help the court. Mr. Vorasi, how much will you give?
Okay. No, you can just go on.
It's crystal clear. It is there.
My lord, what is clear is that that clause, that provision was not followed. And even in the letters that were front-loaded by the claimant, which forms the basis of the payments that were made.
But still under SAN.
Yes, sir.
Supposing if the claimants are given 75% of 25%, can they still be entitled to the remaining 25%?
So, my lord,
Because yes,
what this court will try to determine is
yes,
whether at the time the proposal was made for the
yes,
payment of the pension, especially for those who went on early retirement,
yes.
whether that proposal included a term that we will give you a higher amount, an amount higher than what the handbook says.
Okay,
B,
okay.
after 15 years or after 20 years, as the case may be, we will revert to what the handbook says.
Yes.
There is nothing like that in the letter, which was front-loaded by the claimant. So my lord has to assume. So my lord, first of all, the handbook itself has a time frame, which is 1980 to 2000. So which means that within that time frame, right, assuming the handbook is applicable, it is only applicable to those who retired within 1980 and year 2000 when the handbook was effective.
Okay, that's what the handbook says. That is only applicable.
The handbook has the time frame.
Okay, why is that stated in the handbook?
It's there. It's their exhibit, my lord.
Okay, okay.
Yes.
From 1980 to
2000.
So
to
after 2000 is not going to be
so, my lord, the
applicable
situation
again.
is that some of the claimants retired in 1999.
Yes.
Some retired in 2000, some in 2001 upward. I think the last probably was around 2014, 2015, as the case may be, or 2006, as the case may be. So, my lord, the case we are making as the defendant is that the defendant looked at the scenario and felt if we are going to follow the handbook, the employees, because of the economic situation and all of that, they will be shortchanged. Yes. And so discard the handbook and give them a framework that will be beneficial to them.
Okay.
And so that was done. And that is the reason why in the letter that were, there were correspondence between the first claimant and the defendant. It's not, I don't think it's in this case. I think it's in the second case, in the sister case.
Yes.
Yes. So there were correspondence and the position was explained to them.
There was a letter written by Exxon 26 of 2017.
Yes, my lord.
By Exxon Mobil. Repension compensation request for restoration.
Yes, my lord. So, my lord, our exhibit MPN1 responded to the letter. So this, my lord will notice that this MPN1 is addressed to Mbom John Akpan. Mbom John Akpan is the first claimant in the sister case, not in this case.
Okay, okay.
Yes. Because that is the only
it's okay.
The only individual.
You have formulated two issues. Is that right?
Yes, yes,
so let's just move on from there.
Yes.
You formulated two issues in the written address. Yes.
As a couple places. And we adopt those issues and we urge the court to MPN1, MPN2, and 3. MPN3.
Yes.
Yes, Madam. Well, we adopt those issues.
Yes.
And we adopt the argument advanced in support of the issues
Yes.
as our arguments
Yes.
in this matter. My
Okay.
Lord, we urge the court to dismiss the claim.
Yes.
My Lord, as unfortunate as it sounds, because this case is a borderline, has a sentiment to it. As my Lord will notice, whenever we go to court, the old men, some of the old men will appear.
Okay.
And yes, my Lord.
Is there any way that you can assist them, let us see, so that they?
My Lord,
Is there any way that you can?
My Lord will notice that it took us time to file our response to this matter.
Yes.
Because we were engaging internally with the defendants to see how we can assist.
Yes.
My Lord, there were two challenges here. First of all, we are dealing with situation that occurred 1990, year 2000.
But
so most of the personnel that dealt with this matter, they had left the system.
Yes.
And those who were there they didn't have the materials with which to make a case. And the reason is because 1999, there were no computers. 1999, there was no cloud storage. The storage system in that era was manual. And so it is even difficult to assess documents to be able to say, okay, this is the situation and this is what we can do. And my Lord will notice from the case of the claimant that they still continue to receive their pension, just that they are saying it should be at a certain rate. So their pension continues to be paid, and that's what the letter conveyed to them. The letter, that's MP1, MP2, and MP3. That's the that was communicated. But if there was something that could have been done, I would have been in front advocating that something should be done for them just to ease their situation. So that's unfortunately where we are. We're very grateful.
Mr. Vorasi.
Yes, my Lord.
Mr. Vorasi, you said your claim is not a representative action.
Yes, my Lord.
And then there are so many claimants in it. So, some don't even have their employment letters or retirement letters. How do you, since the action is not filed, by as a representative action, how do you want the court to find for those that don't have their letters linking them with the defendant? Like in the case of the first claimant, he has his retirement letter.
Yes, my Lord.
Yes.
In the case of the others, how do you want the court?
There's nothing. Yes.
How do you want the court to find that claimant number so that doesn't have his employment letter is the staff of because the first thing was to establish that this claimant is a staff of the defendant.
Yes, my Lord, they are staff of the defendant.
How?
My Lord, I say so because even as we are talking now, they are still being paid. And the defendant...
How are they being paid?
My Lord, through their IBTC pension manager.
And that thing is not, there's nothing before the court showing that they are still being paid. They are still, they still have any link with the defendant. Even if somebody doesn't have this, okay, number one, if you are saying that the employment letters are lost, you didn't state that in the affidavit. You didn't state it in the affidavit. And again, even if it's lost, there still has to be something that will link those claimants that don't have their employment letters with the defendant say, that payment that has been made. Produce that document that will show, yes, this payment has been made to the claimant. You understand? As a former staff of
Yes, my lord, that is true.
And that document is never before the court. It's never before the court.
My lord, is true. It's just that we are dealing with people who are old. My lord, the youngest among them is 67 years
but
old.
You are the lawyer. If somebody brought a case to you, you understand?
Yes,
as a lawyer, you are the one that will say, no, bring this document, do you have this, do you have that, do you have this, do you have that?
My lord, we did all that.
If the first claimant has his letter, the others do not have. So how do you want the court to find for the others? And that is one. Number two, Mr. Vurasi.
Yes, my lord.
From the reliefs, you are just saying that they're entitled to you're just saying that they're entitled to the entitlement.
Allowed to be reinstated.
To be reinstated.
To be entitled to be reinstated to 100% of the annual.
I'm trying to get the reliefs. So, Mr. Bruce, it means even the reliefs you are asking, they are not, are they declaratory or directory? What are they? Because number one, in your affidavit, I thought you will have said, as claimant number one, this is this is the amount that I was given. You understand? As my lump sum. Then, and this is the amount I'm being given every month. Every month, this is what I'm given. And for the 15 or 60 months of this is what I've been given. And for the arrears, this is the amount, say like 100,000 naira is supposed to be the arrears that I should be given every month. But Mr. Bruce, you didn't state anything. You're just saying that this should revert to the 100%. No, any computation is made by you. Nothing wrong. You didn't make any computation. In case you are even going to enforce judgment, because when supposing your claims are granted, that you're entitled to so something. It's not. I don't think it's given any directive to the defendant. It's like when somebody is claiming for something, you say that the defendant shall pay me my entitlement. If the defendant went and paid 50,000 naira as your entitlement, because when the court grants that order, how will you enforce it? When you say, okay, the defendant shall give me shall be forced to give me my entitlement, and the court says, okay, the defendant is ordered to give the claimant his entitlement, without stating how much is that entitlement. How can you enforce that judgment? Because the defendant can decide to say, okay, I'm being directed by the court to give the claimant judgment creditor his entitlement. And as far as I'm concerned, his entitlement is one naira. And you just write a letter and give the claimant his 1 naira and say that this is what I know as his entitlement. Like in this case, they wrote you a letter saying that there's no any reversion. And number two, as Mr. Wilson was saying, the handbook was saying 25%. While the claimants were paid 75%. And do you think that handbook applies in the case of the claimants?
Yes, my lord,
Mr. Burasti.
Yes, my lord, it applies. That is the handbook. My lord, is retirement letters before the court.
No, but how does that clause 70, 7 points? How does it say? Let me read you what it says. It says an employee may elect to receive part of his future pension in lump sum. It says the maximum amount to be received shall be 25%. And in the case of your claimant, they are paid 75%. So how does this apply?
My lord, it's 25%.
It says maximum of 25%.
The
Yes,
lump
maximum.
sum that was paid. Yes.
Eh?
The lump sum that was paid, my lord, for 15 years to them.
Yes, but in the case of it says
yes, it's clearly stated in their retirement letters.
But in the travel letter, they were paid 75%, even up to 75%.
No,
but this
my lord,
clause
is
is saying
25% upfront for 15 years. So monthly, what they receive is 75%. My lord, 25% of their monthly pension for 15 years was what they paid.
No, it
now,
says,
my lord, after
Mr. Vras, this is what it says: the maximum amount to be received shall be 25% of the total of 5 years pension paid as lump sum, while the remaining 75% is paid monthly. So it means the lump sum, according to the clause, will be just a maximum of 25%. And the remaining 75% will be, paid as somebody's monthly pension.
Monthly.
But in their case, they are even paid up to 75%.
No, my lord, it's still 25%.
Okay.
It's still 25% they are still paid. Yes.
Eh?
It's still 25% they are paid. But it's
in
the 75.
The
75 is the monthly. The 25 is the cumulation, my lord, the computation for 15 years. The 75% is monthly. So we are saying that they should now revert them to 100%. That is our position, my lord.
Okay.
Yes, my lord.
Okay, I'm going to look at it. But you know that for those that don't have their their retirement letters or employment, the court is not even going to say anything about that because they don't have any link with the defendant. Is that so?
My lord, but the defendant did not, at no time did they deny them that they are not their workers or they are their former staff, my lord.
Mr. Verasi, you win your case.
There was no time. Yes, my lord.
You win your case on the basis of your claims, not on the weakness of the defendant, not on even on admission sometimes.
As the court,
even if the defendant is going to admit that this is my staff, but it's your case, you are the one that will say, will come up with your, will say, this is what I'm entitled to, this is what I'm being paid, this is what I'm supposed to be paid. The money, this is the computation of my arrears. But you just say that you just ask the court to make an order that you're entitled to revert to 100%. It's okay. I'll look at it, but from the
by the time my lord look at it, my lord will appreciate it more. My lord will appreciate it.
Because from what I'm just trying to get this letter reaching to reaching to the claimants.
The defendant.
That letter is
Okay.
From that letter, some were giving 75% of the lump sum. But the clause in the handbook is saying 25%. That's just one of my concerns. So one of my concerns. It's okay. I'm going to look at it. Yes, Mr. Burras, do you have any?
True. My lord is true. But the retirement letters, clearly states it. My lord, they are there. They are retirement letters, those that were front-loaded.
In the retirement letters,
they will be reverted. Yes, my lord.
In the retirement letter, how much? Okay, how much were they given as the lump sum? In the retirement letter, as the lump sum, how much were they given?
My lord, you are giving for this to 25%, 25%, my lord, of the pension for 15 years as a lump sum.
For 15 years?
Yes.
But that
then 75% monthly. Yes, for 15 years, my lord.
But the handbook is saying for 5 years.
Yes, that's the handbook that was in operational then. But even at that time, my lord, same time that they retired, in the retirement letters, it's saying 15 years.
What I'm saying is that if he was given the lump sum of his pension for 15 years, but the handbook is saying just for 5 years. So how do you
for 5 years?
So how do you now? How can you now prove that handbook, is the one applicable in the case of the claimant?
My lord, as at that time, that was what was applicable, and at the same time, during that same period, to when they retired, my lord, it was now
the handbook
15 years.
The handbook is saying for 5 years.
My lord, that's the confusion. There is clearly stated. If my lord will look at it, is there. Okay. My lord will appreciate it. It's saying 15 years pension. But in the handbook, they are saying 5 years.
Okay.
Yes. My lord, they are there. They are there. Handbook is saying 15 years. 5 years. But in the retirement letter, he's saying 15 years.
And I still want to rely on that handbook. It's okay. Are we doing? Do you have any other? So I'll just adjourn.
I don't have any other thing to say than to adopt all that is in our processes.
And it should apply in the others, ba?
As the court pleases.
That is saying.
My lord, save that. Sorry, my lord.
As the court pleases, yes, my lord.
Yes, Mr. Burras, what do you want to say?
Yes, my lord, I'm saying that in the other matter, that's the sister matter.
Yes.
What was paid as lump sum was 40%.
Yes, it still doesn't matter, but it's the same argument, the same.
As the court pleases. Yes, my lord. Yes. Okay. Yes, my lord.
So he's saying the maximum amount shall be received shall be 25% of the total of 5 years. That will be giving you 25% of your 5 years pension as lump sum, and the remaining 75% will be given to you as your monthly pension for up to 60 months. It's okay when I look at it again. The other case, so
Mr.
Ocon. Mr. Ocon. Mr. Ocon.
Yes, my lord.
Which date?
My lord, 21st October.
Okay.
Lord, I was wondering, and I know, my Lord, that this is for, I know that this is for judgment, but
yes.
On that day, I am before my Lord's learned brother, Honorable Justice Baseke Osage in Abuja. I was wondering if we can take the next date.
The 21st is which day, Okon?
Say Wednesday.
Okay, we can take any other date like the Monday, if it's okay.
Is it 19th
or Tuesday? 20th Tuesday.
And on Tuesday is not convenient.
Okay, what about the Monday?
19th.
Okay, Monday is convenient to me. I don't know if it's convenient to the learner.
It's not convenient, my lord. I'm in Abuja on the 19th.
Okay.
Hello, virtual.
So, which date in Mr. Okon?
Hello, can we do virtual?
On which date?
22nd.
Okay, on
Thursday.
I don't know. Well, that's on the second. We can take it on the second, either virtual or
in person,
or physical. Yes. If you can't come from Abuja, we can even do virtual on the second. That's on Thursday. We can do virtual.
Yes, if it's 22nd, I can come to you. If it's 22nd,
the second is okay for us.
I don't
know, Mr. Vurasi, 22nd.
22nd is okay.
Okay.
My lord is convenient. 22nd is convenient.
Physical, we should do physical or virtual.
Physical places.
But as it's convenient, physical it's okay. You can come, my lord.
So which one do you choose? Physical or virtual?
Physical.
Physical is convenient, my lord.
Physical is convenient.
Okay. Mr. Okon.
Yes, my lord.
The other suit number is what?
It's 29.
Okay, 29, 2024.
Yes, my lord.
Is that?
Yes, my lord.
Is that so? Okay, so
yes, my lord.
Given the circumstance, cases adjourned to the 22nd of October 2026 for judgment. This proceeding shall apply in suit number NIC/US/2029/2024.
As a copy,
yes. Thank you.
Thank you. May we be permitted to sign out from this meeting?
Granted. Thank you.
Thank you. Thank you, Mama.
Thank you. Yes. Yes, Mr. Okon.
Okay, my lord. Suit number NIC and UI 12, 2026, between 1, National Union of Road Transport Workers, Comrade Owen James, Godwin Okonedem, Matthew Asukwo, Ubong Ekpene, Jeremiah Augustine, and Honorable Commissioner for Transport, Akwa Ibom State. Government of Akwa Ibom State. Attorney General and Commissioner for Justice, Akwa Ibom State. Mr. Armstrong Monday. The claimants are present in court. The first claimant is represented by the second claimant, National Financial Secretary,
Okay.
and the first defendant is present, represented by Akan Okponete, Esquire, Director of Legal. Second to fourth defendant absent.
First defendant is represented by
Well, first and second defendant is represented by Akan Okponete and third.
Akan.
Fourth defendant absent.
It's represented by who?
Represented by Akan Okponete, Esquire, Director Legal.
This Akan is AKN.
AKAN.
AKAN.
Okponete, OK.
AK.
PONGETEH.
The Akan.
Okay.
AK.
The Akan is AKAN.
And the other one.
Okponete, OK.
Okay.
Esquire.
Upon OKP.
Okay,
NGS. Represent the first, second, and third
defendant.
Yes.
Fourth defendant absent.
Okay, fourth defendant absent. Yes, appearance.
My Lord, with humility,
Yes.
I am Chief Martins.
Chief Martins.
My Lord,
Martins.
Yes, my Lord.
So you've been able to.
Yes, my Lord.
You'll be able to get somebody that will connect you.
But my Lord.
Are you alone?
Yes, my Lord. I am in court, my Lord.
You are alone.
No, I am in court. I'm not alone, my Lord. I am with my learned friend.
You are with who? You are with who?
Yes, sir, we are two, my Lord. We are two, my Lord.
I what? IDOR.
EN. Yes, my Lord.
Okay.
N Y N, sir. Donatus.
Okay. Donna.
Yes, sir. Donatus, my Lord. Donatus. DONATUS.
For the claimants.
Yes, sir. We appear for the claimants, sir. We appear for the claimants.
Yes. Yes. What about the defendant?
Yes, my Lord. Yes, my Lord. My Lord, Victoria, I appear for the first the second and the third defendants.
Victoria, your designation.
Milord,
Your designation.
Senior State Counsel, my lord.
Okay, okay. SSCS. Yes, Victoria, you are for who?
My lord, for the first, the second, and the third defendants.
Okay, second and third.
First, second, and third defendants. My lord.
Yes, okay.
First to third defendants. Yes.
First to third?
Yes, my lord.
Okay, first to third defendant. Yes. Yes. Yes.
Okay.
Mr.
Okay, my lord.
Chief.
Yes, my lord. I didn't know you were referring to us, sir.
I'm referring to yes. The matter
Yes,
is
my lord. Our case is ripe for hearing, my lord.
and we are ready.
Yes, my lord. Yeah.
Yes, Victoria. Victoria, are you ready?
My lord, I learned that the claimant counsel.
You are in court on the last agenda.
Yes, my lord. My lord, the claimant counsel has responded to our counter affidavit and has filed sent.
Yes.
I do not have a copy of, yes. My lord, I have not seen the copy of that process, but it's in court there. He informed me this morning.
Yes, and it was served on you, on the ministry.
Yes, my lord.
So
my lord, the process was served on the representative of the ministry this morning in court.
It doesn't matter. It doesn't matter, Victoria, whether it's served on the representative or is served on the ministry.
Yes, Lord. My lord, we would love to have looked at it just in case we have a reaction.
But when you came this morning, why not giving a copy?
No, my lord. My lord, I am not in the same premises as the claimant counsel.
Hello.
Yes,
hello.
Lord.
Yes.
I'm saying that, Chief, what did you file as your response to the counter affidavit?
We find a response on point of law, sir.
Oh, how many pages?
Just about 4 pages.
Because even on last agenda, you are saying that it should be as simple as.
It's just to respond on point of law. I didn't go on fact.
Yes. And she's now saying that she has not, had a look.
Because she's not, if she were in the premises, it would have been given by her representative. I said, if she were in court, she's not in court. It has been given to the ministry.
Yes. She even acknowledged that.
Yes.
So what do you do now?
Oh, no, we can go on just to adopt. There's nothing we are doing. We only reacted on point of law. That's all. We didn't go on facts.
Yes, since it's already served. Victoria, that document is served on you. Whether you don't have any right to react to it again. You understand?
She doesn't have the right, sir.
Eh?
She doesn't have the right to react again. It's a point of law.
That's what I'm trying to tell her.
So we can adopt our processes.
As the court cases.
Okay, so Victoria, we should go on back.
Yes, ma'am.
Okay, so Chief Martins, yes.
Yes, my lord, we are ready, sir.
Yes.
My lord, before I start my presentation, my lord, I would like to refer my lord to our relief number 10 on the originating summons, sir. I want to make some corrections.
Oh, sorry, Mr. Martins, just give me 2 minutes, please.
All right, sir. Sorry, sir. Our relief number 10 on the
just give me 2 minutes. Give me 2 minutes.
Sorry, sir. I'm sorry, sir. Okay, sir. Okay, my lord. Snap this thing and send to your lawyer. You don't do it. In the WhatsApp. Okay. Why can't you use the number and do it now? You have the number is audited. You should attend to that.
Sorry, yes, Chief.
Yes, my lord.
Yes, Chief Martin, sorry.
Yes, my lord. Yes, my lord. My lord,
Yes,
I was saying,
yes,
my lord, I was saying I have issues in my relief number 10 on the originating summons, sir.
What issues?
There is a typographical error in line 3 of relief number 10, sir, that which we want to apply with the leave of this court to do the correction, sir. It is not injurious to any party. Relief number 10 on the originating summons, lines 3.
What's the relief number 10 saying?
Relief number 10 says that an order directing the defendants to pay first claimants the total sum of 2,240,000 naira daily, being accruable revenue for, instead of first claimant, we now write the first defendant, sir. It was a typographical error. We want to correct it.
Okay.
From first defendant to first claimant, sir.
Okay.
With the leave of this honorable court, sir, we are seeking the leave of court to change it from defendants to first claimants. From first defendants to first claimants.
The word first defendant should be changed to first claimant.
Yeah, to first claimant, sir. That is just what I want, sir. I am seeking the leave of court to effect that correction from first defendant as written there to first claimant. We intended to put in first claimant, not first defendant. So it is a typographical error from the secretary of our officer. We are very sorry, my lord.
Yes, Victoria, any issue?
No, my lord, no.
No issue.
No, my lord.
Thank you, my learned friend.
So application is granted as read.
As the court places. My lord, we are grateful, sir.
Thank you. Yes,
We are
Mr.
grateful,
Chief.
my lord. Yes, my lord, we have before this honorable court
Yes.
an originating summons.
Yes.
That was filed on the 23rd day of March, 2026.
Yes.
My lord, we have presented 5 issues on the surface of the originating summons for determination by this honorable court. 5 questions or issues to be determined by this honorable court.
Yes.
And we also have, pardon my lord?
Yes, I can hear you, yes.
Okay, we have 10 reliefs. After my lord has determined the issues, 5 issues in our favor, and we seek 10 reliefs from this honorable court, sir.
Yes.
My Lord, the originating summons is supported by an affidavit of 31 paragraphs. Affidavit of 31 paragraphs, my Lord.
Yes.
Deposed to by God Conrad Kodunokun Edem, the third defendant, the third claimant, my Lord.
Yes.
Before this honorable because the third claimant, sir.
Yes.
My Lord, we have about 5 exhibits to support our claim.
Yes.
Labeled Exhibit A, Exhibit B, Exhibit C, Exhibit D, and Exhibit E.
Yes.
My Lord. And we also have, in compliance with the rule of God, we have our written address attached to the originating summons, sir.
Yes.
We urge this honorable court to take, we hereby rely on the facts deposed to in the affidavits and also the exhibits all the exhibits.
Yes.
Particularly, my Lord, Exhibit E, which is the public announcements by the defendants. Exhibit E, my Lord, is the public announcement by the defendants directing the claimants to register with them biometric registration so that all the check-up dues will be paid into the Akwa Ibom State single treasury accounts. That is the content of Exhibit E, sir. So we hereby adopt our written address, my Lord.
Yes.
As our arguments in support of our case, my Lord. In our written arguments, we have raised 4 issues for determination, and we have accordingly presented our arguments on those 4 issues.
Yes, open been served with the counter.
We accordingly, yes, my Lord. Upon service of the defendant's counter affidavit and written address on us, my Lord, we further filed our claimant response to defendants on point of law, sir, on the 21st day of July 2026. It is a response on point of law, sir. We further adopt this process as our additional arguments in support of our case. We adopt this response on point of law as our additional arguments.
It's filed when the reply on points of.
Yes, on point of law, sir. It was filed on the 21st day of July, 2026.
Okay.
Yes, my Lord.
Okay.
And we urge the noble courts.
21st of July.
Yes, sir. Yes, sir. 21st day of July 2026. That's when we filed our response on points of law.
Yes.
And then we urge this honorable court finally, my lord,
Yes.
to adopt, apply the principle of international best practice to determine this case in our favor. We urge my lord to hold that we have proved our case.
Okay.
And the claimant deserves the relief sought. We are grateful, my lord. Yes, sir. We are
Thank you.
grateful.
Victoria.
Yes, my lord.
You are conceding? You are conceding to the...
Yes.
Huh? Yes, Victoria.
I can hear you, my lord.
Yes.
Okay, my lord, having been served with the originating summons of the claimant, the first to third defendant filed a 16 pages counter affidavit. And in compliance to the rules of the court, we filed our written address. My lord, it is dated the 13th day of July 2026.
Yes.
We rely on all the paragraphs of our counter affidavit and adopt our written address the argument in this case. In our written address, my lord, we have raised just two issues for my lord's consideration. And we are urging the court to answer all in the negative and resolve the issue in favor of the defendant. We urge this honorable court to refuse all the relief sought by the claimant and dismiss the originating sum of the entire. Thank you.
Thank you. Do you have exhibits?
No, my lord.
Okay. Mr. Okon, which date? Mr. Okon.
'19th, my lord. 19th of October.
October 19th. Okay. Oh, this. Oh, yeah. This 19. Okay, this is the right. October. Okay, 19. Okay. Well, it's confident. It's confident.
It's okay.
Yes, my lord. 19 is confident to us, sir.
Okay, Victoria, is that okay?
Yes, that's fine.
Okay, so given the circumstance, case adjourned to 19th of October 2026 for judgment.
As the court pleases. My lord, we are very grateful, sir.
Chief, thank you so much.
Yes, my lord, we are grateful, sir. Thank you, my lord.
Thank you. Mr. Okon.
Yes, my lord.
Any other thing?
None, my lord. None, my lord.
Okay, so Chief Martins.
Yes, my lord.
Victoria Inyang.
Yes,
my lord.
I wish you good afternoon.
Yes, my lord.
Good afternoon, sir.
And in the absence of any other thing, I have to call it a day.
Thank you, sir.
So I thank you so much.
Thank you, my lord.
Thank you, my lord. Enjoy your vacation, my lord.
Thank you. Thank you.
My lord, enjoy your pleasure, my lord. I hope I will see you again at the Port Harcourt conference.
Conference, yes, God willing.
Thank you, my lord.
Thank you so much. So I leave. Thank you.
Yes, I believe.
Oh, thank you.
Right?
Hold on. Okay, sorry. Disconnect now.